Broadcasting from the studios of Business Radio X, it's time for Privacy Cafe. This show is brought to you by Hall Booth Smith, guiding clients through the intricate landscape of data privacy law. Now, here are your hosts.
Welcome to the Privacy Cafe podcast, where we blend legal data privacy insights with the perfect cup of coffee. I'm Jade Davis, and I'm here with my co-host, Rich Shanus. Today, we're going to cover the Becerra case, which recently overruled the HHS guidance about the use of tracking technologies. Rich, take us away.
Thank you so much, Jade. This particular case that you just mentioned, the Becerra case, is near and dear to my heart because I happen to be dealing with some class action suits on the defense side, of course, that this case is very germane to and very good on the defense side. Let me give a little bit of background of how this case came about. We all know that under HIPAA, medical providers cannot just share or disclose medical information about patients. That's old news, 30 years old. And what happened was about 2 years ago, 2022, HHS came out with what they call a bulletin or guidance. And they said that hospitals or other medical providers that are using what we call common tracking technologies. People are familiar with the word cookies. Pixel is another word for a similar technology, WebBeacon. We'll just call them cookies. And HHS said that when medical providers use these cookies, what the cookies do is they get information about or gather information about people that visit a website. So it might get the IP address of the device the person is using, and it usually will be used to analyze what pages on the website the person goes to, how long they stay on the web page, and compile various analytics. And so HHS came out and said that when medical providers use these cookies, what they are essentially doing is they are sending protected health information of individuals to the companies that provide these cookies. And there are several, but I'll use the main ones at issue are Facebook/Meta. They have a Pixel. There's Google Analytics. I'll really talk about Meta and Google, not that they're doing anything wrong. And so by using these cookies, Meta and Google were obtaining this information about people who went to the hospital websites. And HHS said that's an unauthorized disclosure of individually identifiable health information about the individual who's doing the browsing. And by sending this information to Google or Meta through their cookies was an impermissible disclosure, unauthorized disclosure in violation of HIPAA. What that did was it set off a flurry of class action lawsuits against mostly hospitals, but other medical providers across the country saying, hey, you hospitals are violating the privacy rights of all these people that go to your website, which is going to generally be in the thousands and thousands, because you're taking all this information and sending it to Google and Meta. So following all of those lawsuits, the American Hospital Association themselves filed a lawsuit essentially against HHS. The named defendant is Xavier Becerra. I believe that his official title is the chairperson of HHS. And the American Hospital Association challenged this notion that sending the cookie-related information to Google and Meta violated HIPAA. And the premise was this information is not identifiable. You cannot take, just because it's someone's IP address and what they search on a website, it does not identify any individual. And its health information has to be tied to a particular person to be identifiable and subject to HIPAA. For example, if you said there's a person in New York City with cancer, obviously that could be millions of people. So that's not identifiable to anyone. On the other hand, if you said there's a person in New York City that lives at 123 Main Street and they're over 50 years old, you're probably identifying a person, and that is identifiable. So because of this lawsuit by the American Hospital Association, HHS issued new guidance, new bulletin in early 2024 to get around the issue. And this tweaked guidance said that the information gathered by cookies is only identifiable and therefore subject to HIPAA if the person doing the searching on the website is searching it for their own needs or purposes, for their own condition. So, for example, if a person is suffering from a particular medical condition and they go to a hospital website and they search a hospital website for gastrointestinal physicians, or they search for bariatric surgery, that is identifiable information and not permitted. That's the way they tried to tweak things a little bit. So what do you think there, what HHS was doing with a little bit of a sleight of hand?
Absolutely. I have so many questions just as far as how we come back from this. Should companies feel comfortable proceeding when using these online tracking technologies, or should they halt?
They should still use them. There are a couple of best practice notes that I'll give as we move on through the podcast. This is by no means am I telling hospitals or medical providers that they should not use tracking technologies. There are just a few things that they should do to make sure that they're using them properly. So what has happened, and also that helps medical providers with these technologies, is along comes the Becerra decision. And I really, honestly, I love this decision because it's written by a judge and it's Judge Mark Pittman. He's a district court judge in the United States District Court for the Northern District of Texas. And he tells it like it is. What the Becerra opinion said is to think that the information gathered by cookies is tied to a person is ridiculous. And HHS does not save their guidance with this sleight of hand revision by saying, oh, if it's the subjective intent of the person browsing the website to do it for their own use, then it is identifiable. The Becerra decision, Judge Pittman said baloney to that. Because when a person searches a website, first of all, are they using their own device? Are they using someone else's device? They could be at a library on a public device. So the IP address does not identify the person necessarily. They could be searching it for themselves, but they could be searching for someone else. I know my own personal experience with an elderly father. He does not have a computer. He does not search the internet. There have been plenty of times I searched things on the internet for him. What about a person maybe, let's say they're 40 years old, but they have a history of Alzheimer's in their family. And this person says, oh, you know what? I'm really concerned. Could I get this genetically? Even though I'm only 40, I don't have Alzheimer's. And so they go on a hospital's website and they look up information about Alzheimer's. That doesn't mean anything about my medical information or that I have a condition. So a combination of those, Becerra said, or Judge Pittman in Becerra said, there is no way in the world a hospital can know what is the intent of the person doing the searching. First of all, there's thousands of searches that are done every day, likely. And how in the world can a hospital know if Jade Davis is searching a hospital website, is Jade Davis searching that website for her own medical condition? Is she searching for a doctor for herself? Or is she doing it for a family member or for a friend? There's no way in the world a hospital could know that. So that's why this subjective intent that HHS threw in there, saying, well, if it's subjective intent that the person's searching for their own purposes or their own use, then it is identifiable health information. There's no way a hospital could know that. And that's why that subjective intent test is basically nonsense. And that was the prescribed combination. Jade, I threw your name in there. I don't know if you've searched any websites for information, but what do you think about that?
I search websites all the time. I search websites for my own clients. I search websites when I'm just curious about something. It just seems to me that it was very overzealous for OCR to move forward with that bulletin. And I just don't know where we go from here. I checked the bulletin when we were talking about this case, and they have a disclaimer at the top that cites the Becerra decision. And it states that the portion of their guidance that was vacated. And at the end, it says HHS is evaluating its next steps in light of the order. So what do you think about how and why they felt that they had the authority to move forward with such a broad guidance? And do you foresee an appeal? Where are we going from here?
Yeah, I think HHS is trying to save face, honestly. I think the Becerra decision really threw the HHS guidance back in their face. Judge Pittman really used some, I'll call it some pretty strong language about HHS. Judge Pittman said that HHS revised their bulletin and tried to tweak the definition of individually identifiable health information and got caught with its hand in the cookie jar. Not very complimentary. And he said HHS now backtracks that HHS is gaslighting. Gaslighting is lying. Is gaslighting the hospitals. And let me read something to you because this ties in amazingly to a recent decision from our Supreme Court, not on this specific topic, but we're familiar with what we're calling the in a sense, overturning the Chevron decision. But here's what Judge Pittman said. This case isn't really about HIPAA, the prescribed combination, which was the IP address plus the search, or the proper nomenclature for PHI in the digital age. Rather, this is a case about power. More precisely, it's a case about our nation's limits on executive power. How's that for throwing it back in HHS's face and telling them you are out of your league, you've gone way beyond your bounds? Judge Pittman even quotes the Bible, and he said, but a wise man once said that one who is faithful in a very little is also faithful in much, and one who is dishonest in a very little is also dishonest in much. And that's from Luke 16:10.
Wow.
Judge Pittman went on. Yeah, when do you read a court opinion with such strong language criticizing a party or a federal agency? And Judge Pittman, and this also really hits home, while the prescribed combination may be trivial to HHS, it isn't for covered entities diligently attempting to comply with HIPAA's requirements. And even small executive oversteps can compound over time, resulting in larger transgressions down the road. What the HHS bulletin did, it set in motion a snowball rolling down the hill, getting bigger, of plaintiffs' class actions. So hospitals who do their darndest to comply with HIPAA all of a sudden get hit with, oh, by the way, all these cookies that companies by the thousands across the world use, you're violating HIPAA. And so it has cost countless hours and millions of dollars for hospitals to defend these lawsuits that was started by HHS's gaslighting. That to me is a very big bottom line. And I mentioned Chevron. The reason this ties in, recent case in June, Loper Bright Enterprises versus Raimondo, that's the one that overturned the Chevron decision from 1984. Chevron gave great latitude to federal agencies to pass regulations, which were in fact laws. And this new decision overturned Chevron and said, no, wait, these federal agencies are going way beyond their power with these regulations that have the force of law, and you cannot do this. That, to me, is very much what Judge Pittman is saying in Becerra with HHS. You are going beyond your regulatory powers. You are trying to pass these bulletins or guidance that have make them have the effect of law. You don't have the power. That's why I think Judge Pittman's decision is important, and I know darn well I'm using it to bring to the court's attention in this type of class action that I'm handling as well.
Absolutely. I can see some indented excerpts and quotes, some good stuff to put in our reply brief or motion to dismiss. Before we wrap it up, though, how do you think the decision affects current or ongoing class action suits or future class action suits?
Yeah. From the strictly legal perspective, Judge Pittman's decision is technically not binding on courts throughout the land. So, for instance, cases that I might be handling in state courts, not in Texas, in other states, a judge could say, I don't care what Judge Pittman said. I don't think he's right, and can disagree, and they can do that. It's not like when the Supreme Court issues a ruling and all the courts below it have to follow it. So it's not automatically going to affect all the class actions around the country. But it is the strongest and best reasoning and language that I have seen to affect these cases. And like you just mentioned, it's in our briefs. So I think it will have an effect on these pending cases. A lot of judges are not familiar with this area of law and rely on the other courts. And I've not seen anything since the Becerra opinion that in any way counteracts it.
Yeah, because many were thinking that it would be appealed. And if it was appealed, there certainly could have been a basis to stay those class actions until it's fully resolved. So I'm really interested to see what sort of revised bulletin is released by HHS, if they release one, or what happens from there.
And it'll be, I'm sorry, I was just going to say, it'll be interesting to see also, does it give plaintiffs' attorneys a little pause on filing future lawsuits? We'll see if those slow down a little bit. But Jada, I think you're about to ask if I have maybe any tips for future practices and some best practices. And as I said earlier, I am by no means telling hospitals or medical providers not to use cookies. What I would recommend is have a good inventory of what you're using, a written record of not only the cookies you're using, but a lot of these tracking technologies like the Metapixel or Google, they have what are called dashboards. They have what's called event managers, where the hospital can determine what information the cookie picks up. And so you have some control over what information goes to the Googles, the Metas, and so forth. The other big thing is what we've been talking about are basically your public websites, just anything that's out there. I differentiate that from what hospitals and medical providers have, which are known as the patient portals, that are password controlled, because then when a person's putting in their password, then they are identified, and it's only a patient that has access to the patient portal. So that's a different situation as far as being identifiable. Generally, my experience has been hospitals do not put the Metapixel or Google Analytics on patient portals. but it's a good idea not to do those types of things, or if you do, really review it. So patient portals are treated differently. You need to be more careful, and that is because the patient portals do specifically identify patients, as opposed to what I'll call the public portions of websites, which are open to anyone in the world that wants to access the website and do a search.
Very good. I love those tips, and you know me so well. I certainly was. Just want to give our audience some takeaways that they can implement and bring back to their teams. And if that's all for the good of the order, I'd like to thank everyone for listening. Privacy Cafe is underwritten by Hall Booth Smith, and the show is part of the Hall Booth Smith Podcast Network. For more information, you can visit our website, hallboothsmith.com, visit our blog, Data Privacy and Cybersecurity Group, sign up for our newsletter. There is a clear and conspicuous link at the top and the side of our page to get alerts and information from us monthly. Additionally, you can find Privacy Cafe on the Business Radio X network and all major podcast apps, including Apple, Spotify, and more. See you next time.
Thank you for joining us on Privacy Cafe. This show is underwritten by Hall Booth Smith, helping clients navigate the ever-changing world of data privacy and cybersecurity. For more information, go to hallboothsmith.com.
Privacy Cafe is a production brought to you by Hall Booth Smith, PC. This podcast is published for the purpose of providing general information and education on topics, which includes those related to the law and legal issues. But the contents of the podcast do not constitute legal advice. Listening to this podcast or utilizing the information contained in it in any way does not constitute, nor does it create, an attorney-client relationship between you and Hall Booth Smith or its lawyers. The contents of this podcast should not be used as a substitute for competent legal advice from a professional attorney licensed in your jurisdiction.